Hello students, my name is Udana Soisa. I've done at law. I've been a lecturer with the University of London for nearly a decade now. In this short series, this 5 minutes series, we will learn the basics about various subjects within the University of London syllabus, ranging from contract law, criminology, jurisprudence, criminal law, international law, even to areas such as legal systems, public law, trust and equity, property law, and etc. So I hope that you stick with us and learn to think and analyze through these little videos we are bringing to you. So in this little video today, we will learn the very basics of contract law. A lot of students find contract law to be a difficult area, but the reality is contract law, in fact, is probably one of the most easiest areas that you can tackle if you actually get the basics of contract law. First point that I would like you to know is imagine a person. Imagine a little drawing of a person where you have a head, you have a backbone, you have 2 legs and 2 arms. So if you can just take a little paper and draw a person. We will call this person as Mr. Contracts. Mr. Contracts will have a head, a backbone, 2 arms, right, and obviously 2 legs. So what's up with this? Contract, as a starting point, one needs to think it as a person. Almost. Many of you might find this very confusing. Let me tell you how to think about this. Can a person clap with one hand? If I give you a hand and say, show me your hand and clap with one hand, are you able to do it? The answer is no. Same thing. The starting clap or the starting point of a contract is offer, which is met with acceptance. So if one hand of Mr. Contracts is deemed or is viewed as an offer, it should be met with the other hand, which is acceptance. So offer together with acceptance forms the very basis of a contract called the agreement. Offer and acceptance forms an agreement, not a contract though. It forms an agreement. So how can an agreement be enforced? How can a person walk? For a person to walk, for a person to stand straight, for a person to move around, he has to have a backbone. If you don't have a backbone, you can't do anything that I'm doing right now. Similarly, with a contract, to enforce the backbone of the contract is consideration. If you have an agreement without valid consideration, it will not be enforceable. What is consideration? McHenry in your textbook views consideration as the badge of enforceability. Right? And what are these 2 legs? Certainty and legality. For a contract to be binding, it has to be certain. I can never contract with you. Let's say I want to sell, let's say, a car. I would like to sell this car. For me to sell this car, I cannot say, hey, I will sell this for around £20,000. No, I can't say that. I will sell it for £20,000. That's it. Not on about, not for around. It should be exactly 20,000. So again, the contract has to be legal and contract has to be certain. We already spoke about certainty, now legality. As you see with cases such as Balfour versus Balfour, domestic contracts are never meant to be. Hey, yes and never. There are exceptions. Though domestic contracts or domestic agreements are never presumed to be enforced, there are exceptions, such as when parties are separated and also when parties are with a commercial focus. So again, if you look at this person, one hand is offer, other hand is acceptance, the backbone is consideration, one leg legality, other leg certainty. Contract has to be certain as well as legal. So what's the head? The quality of a person is dependent on the person's head. So the head of Mr. Contracts, we can deem it as terms. Terms which are also known as the content of the contract determines the direction of a contract. So I would say the head of the contract or head of Mr. Contract is terms. Right? So there are two types of terms, major terms and minor terms. Major terms we will understand it as conditions. So when you break a condition, it will lead to the contract being void. Minor terms we deemed as warranties. Minor terms are warranties. When you breach a minor term, obviously there is no possibility to void the contract. In that context, one can seek damages. To re-summarize, for a valid contract, the offer has to be met with its mirror image acceptance. It has to be enforced, right? For that, there has to be consideration. The consideration is the badge of enforceability. For example, you would like to pay 20,000 and buy a car. I promise that I will sell my car for 20,000, so you provide me with the consideration that is 20,000. So that 20,000 which comes from the promisee is a consideration and is a badge of enforceability. Finally, when it comes to the other two aspects, legality, we know from the case of Balfour versus Balfour that domestic contracts are not presumed to be legally binding. And we also know from McKendrick and other case law, a contract or even for an offer to be valid, it has to be what? It has to be certain. Finally, every contract will have two types of terms, right? Major terms, minor terms. Major terms we use the word conditions. Minor terms we use the word warranty. There are also a third type of terms called innominate terms. So what are innominate terms? Innominate terms are terms which are neither conditions or warranty. We will figure it out once the contract is breached. So if the breach of an innominate term is serious, that means the innominate term should be treated as a condition. If it is a non-serious breach, it will be treated as a warranty. So I hope you are able to grasp this. If you understand this very basic structure of a contract, you are able to study or start your studies in a very analytical manner than just memorizing a note. So thank you. I hope you will enjoy our future videos. Stay tuned. Thank you.